don't bother putting these things into prenuptial agreement. For example, penalty for cheating. If you cheat on me, you have to pay me $50,000 for each time. Not enforceable. California is no fault state. That means all you need is irreconcilable differences, no matter whatever the reason is for divorce. Second, anything child related. Well, if we have children, then I can move to Germany. Or if we have children, I can get child support in the amount of X, or the custody is going to be sole custody to me. Doesn't work. It's against public policy. Or if you gain weight, you have to pay me money. More than 50 kilograms, 110 pounds is punishable, not enforceable. However, there are things that you can put in the prenuptial agreement, and those things are, for example, division of assets. As we know, anything I earn before marriage is your separate property. Anything accumulated from the date of marriage until the date of separation is community property. However, in the prenuptial agreement, you can classify that everything is your separate property, or, for example, if we buy a house, California law says I can get reimbursement to my separate property, 2640 claim, dollar for dollar amount. So, for example, if someone buys $1 million house and pays $200,000 down payment, then 20 years later, that person gets $200,000 back? That's ridiculous. So a prenup could say, I get either with 10% interest back or proportionate to the value of the home, which means if 200,000 was 1/5 of the home that was 1 million, then if the home is now 10 million, then it's going to be 1/5 of the 10 million. Make sense? So we change a little bit California law in that regard. Spousal support. Spousal support, as we know, is half of the length of a marriage, typically awarded from the higher earner to the lower earner spouse, and it's approximately 35% of the difference. Now, spousal support can also be capped at either percentage of the 35%, or it can be capped in the amount of dollars. So, for example, if someone makes $3 million, 10% of spousal support is a lot of money. But if you say 10% or no more than $100,000, voila, spousal support provision it is. I have bad news. Last year, case of appeal, list case, came out saying that prenuptial agreements now presumed to be invalid. Can you believe that? Until the court says it is valid. And so what it does mean is that if a spouse who wants to challenge the prenup challenges it, loses, in the meantime, for these 2 years, the higher earner has to pay temporary support. However, the spouse who loses then has to pay attorney's fees for the other spouse, and the other spouse can get all spousal support paid back. So it created a big mess, I would say. I don't like this case of appeal. Next reason, debt. The prenuptial agreement can also say who is going to be carrying the debt. For example, if someone incurred credit card debts or student loan debts, technically it's their separate property. But if we want to keep it even clean, because there are exceptions to these rules that I'm not going to dive into in this video, we can keep it clean in the prenuptial agreement and say no matter if community benefited from these debts, it's still yours. Thank you very much. Next, financial responsibilities during the marriage. The prenuptial agreement can define what we're going to do during the marriage. For example, one provision could be we open a joint account and each of us puts a certain percentage of each of our respective incomes into that joint account so that we can pay for our living expenses. I don't like these kind of provisions because prenuptial agreement is usually designed for the case when divorce is happening. So you don't want to micromanage the marriage too much. Usually what I do is I say, look, we open a joint account in my prenuptial agreement, and then we use that money to spend on living expenses. I don't define how much. It's just there. And I consider it community property account, period. If divorce happens, that account is split equally no matter who put how much. Next, retirement benefits. Typically, whatever one spouse earned before marriage is considered their separate property, and whatever they earn and put into retirement during the marriage, it's community property. We can say in the prenup, everything is separate, or we can say we would like to follow community property law. Inheritance. I don't like to put anything regarding inheritance because prenuptial agreement is designed for the case of divorce, not the case of death. What I do put, however, that each spouse or both spouses are free to create a will or trust of their choosing after they sign this prenuptial agreement. And typically what happens, the spouses will show to the estate planning attorney what the prenup says so that the estate planning attorney can create a trust. And finally, the prenuptial agreement has procedures resolving any disputes out of the prenuptial agreement. For example, if it goes through divorce and there is a disagreement about the validity of the prenuptial agreement or the clause about spousal support, we agree to go to 3 sessions at mediation and attempt to settle it amicably. But if not, then we can go to court. That's one way to have procedures. Attorney's fees. There is a clause that could say, if you challenge the prenup and you lose, you have to pay my attorney's fees. Or it could be another attorney fee clause. If I need to enforce this prenuptial agreement, then you have to pay my reasonable attorney's fees pending enforcement, need-based attorney's fees. I hope this video was helpful. Click like, subscribe. If you have ideas for my next videos, please comment down below, share this video, and I will see you in my next consultation in California. Bye!